can you protect an inheritance in your divorce? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. One of the concerns that people often have when they're looking to split up assets in a divorce has to do with inheritance. Somebody passes away, they leave you an item, they leave you a home, they leave you money. Can you protect that from being split in the divorce? Well, the answer is you can take steps to protect those items. The key is if it's an inheritance, then it's protected. If it's not an inheritance, it's theoretically up for grabs. If it was an inheritance and you changed it into a non-inheritance, then it might also be up for grabs. So that last example is what you got to watch out for. And what do I mean by an inheritance that became a non-inheritance? Very simple. Suppose somebody passes away and they leave you a fidelity account. There's $100,000 in it. Well, it's your money. It's $100,000. It's at least at this point in time, it's not a marital asset. If you then take the money out, open up a bank account at Chase in your own name and put it in there, it's a good position to have to be able to say, you know what, that was my inheritance before. It came from here. That's where it was. I kept it separate. It's mine. It's my separate property before. It's still separate. But if you take that money and you take it out of the fidelity account and you put it in Chase in your joint account with your husband or wife, what you have essentially done is you've made a present. You've gifted your own property to the marriage. And then 3 years later, when somebody files for a divorce, don't be surprised if they ask for half that money. Because you've essentially taken a single asset and commingled it with a marital asset. You have taken an inheritance and made a non-inheritance out of it. You can do the same with the house too. You get a house, it was in your dad's name, he died, now it's in the name of the estate. The estate is administered and pursuant to the will, it gives the house to you. Now it's in your name. The moment you take that house and you quit claim it from yourself to yourself and your husband or your wife, the moment you do that, you've made a gift from personal property to the marriage. Gift to the marriage. Well, a gift is a gift. You're going to be hard-pressed to be able to defend it later on. So when you talk about protecting inheritance from divorce, the main protection is keep it as an inheritance. Document it. Document when you got it, how you got it, that it was inherited, how it came to you, a copy of the will, a copy of the bank statements, and then there won't be an issue. There may still be an argument to be made that yes, that $100,000 was yours. Yes, it was an inheritance. You still get to keep it, but during the marriage it grew. It grew from $100,000, now it's worth $125 with interest and reinvestment and all that. They may argue for a piece of that 25, and you can argue, no, I should be able to keep this because it directly flows from the inheritance that I got, and my dad anticipated the growth of that when he gave me the corpus of the product, when he gave me the fund. You can argue that. And the court can take it into account. And if equity prevails, the court might say, okay, you keep this and the proceeds. But the court may look at the overall situation and say, you know what? It's more fair to divide the proceeds. So that's something that's up to the guy in the black robe. You can argue about that. But if you want to at least keep the main corpus of it, one of the best ways to shield against any claim to it is to always maintain it as a separate asset so that it is clear that that is your inheritance. If you have any questions about that, reach out. We're glad to help you out.